And hello, everyone, and welcome to the Copyright 2.0 show, episode number 335. My name Jonathan Bailey from the site Plagiarism Today, which can be found at plagiarismtoday.com. And joining me, as usual, the man who always gets the job done. It is Patrick O'Keefe at the iFroggy Network at iFroggy.com. Patrick, how have you been?
I'm doing okay. How are you?
Doing good, doing good. You're putting everyone to shame with your productivity these days, getting things done, knocking it out, getting to
Yeah,
work.
I'm trying. Making progress. Making progress. In all facets. I was just going through my closet and getting rid of clothing. Actually, on a personal
Oh,
productivity note, getting rid of clothing doesn't fit, or I bought pants that are too big, and it's gotten worse because pants that used to fit okay now don't fit anymore because I've lost some weight around the midsection, and I'm gonna sell them if they have value on eBay. If not, off to donation.
oh well, there you go. That's a good. It's weird you mentioned clothing because Crystal was actually. We've been doing. I mentioned to you before the pregame show. We were doing some rearranging in our house,
Right.
converting the use of some rooms and doing things like that. Well, Crystal found some of my old clothes, and here's one item that's particularly interesting. My old soccer jersey from when I was younger, and specifically from when I was actually 10 years old. And it's interesting because this is the year we won the championship in our league.
Oh, nice.
It's the championship
It
jersey.
looks like it could fit you now.
No. Hang on. No.
Okay, you're like, your eyesight's not good, Patrick. Now, I guess it's a matter of perspective. If you hold it up in front of you like this,
Yeah.
it looks
Yeah.
like good, but when you put it against your body, it doesn't look so good.
Yeah, it doesn't look so good up here, but up here, yeah, it looks like it definitely still fit.
Yeah, it fits perfect right now.
Yeah, it's perfect, like 2 feet in front of me. But the other item I wanted to show you that was interesting was it's kind of faded now because it's been about, I don't know, almost 20 years. But this shirt was signed by the comedian Kathy Buckley, a deaf female comedian. And she came and spoke at my little brother's school. My parents got through to her agent, got her to come give a motivational speech. My brother's hearing impaired too, at his elementary school. And I got to meet her and hang out with her a little bit. And she gave me this, and the actual signature, what she signed it is Jonathan, where is my date? And that has to do, she has a joke, like I said, she got a cochlear implant, or she got hearing aids, as far as hearing aids, and the first thing she did was she was fascinated that paper makes noise. I mean, and actually, no, the joke from the date, sorry, I'm telling the wrong Kathy Buckley joke. The joke of the date is I haven't had a date in so many years, I don't know if it's because I haven't heard the phone ring or what. And simple throwaway joke, and so I made a quip. I would go on a date with you, and then that's what she signed the shirt. I was 16 years old at the time she did that, so there you go.
That's funny. Yeah.
So we found
Those. She
those.
has a website, kathybuckley.com. Yeah.
Oh, yeah. She's still around, best of my knowledge, still
Yeah.
touring and stuff.
Still speaking or preparing for a website.
Yeah, she was a really, really wonderful woman. Very, very interesting, very introspective, and had a very good career as far as stand-up comedy goes. And I guess now she's done more of a taking more of a motivational speaker route, but still fascinating.
Yeah. Very cool.
Like I said, the
Good
joke I was
story.
going into was she was fascinated that paper, when you crumple it, makes noise. She didn't realize that until she got her hearing aid. And so she went through her house and got every piece of paper, every type of paper she could find, and laid it out on the table. And it's like notebook paper, yeah, butcher paper, yeah, there's that, like aluminum foil, anything paper-like. Then she got down to the tissue paper, and it's like, what's up? What's going on? Talk to me. Come on. Is this thing on?
That's funny.
So.
That's a funny story.
So that
Yeah, I
was
have to imagine. I mean, something we take for granted. You just
Yeah.
don't know what anything sounds like. It's just
Yeah.
one of those senses. If you've never had it, then I guess you're not used to it. But the moment you get it, it's a big deal.
Yeah, and as my brother got a cochlear implant, not long after meeting Kathy Buckley, actually, not long after that whole thing went down, he talked about, for him, even though he'd had hearing aids and had been able to hear some, there was still this constant barrage of what was that? Every few minutes, oh, that's what a car sounds like, when it's just driving by. He might have heard, what a car sounded like when it started up. You could hear that with the hearing aids, but just that low hum of it going by on the street outside at the house, couldn't hear. And so he's got that. It's like every few minutes, like, what was that outside? What was that? Oh, a car. Interesting.
I better go chase it.
Yeah.
No
I don't think
disrespect to your brother.
no. I get the jokes there, but no, I don't think he ever thought that. But it
Yeah,
was
because
very.
almost the way your neck movements are, it's like a dog almost. The way you were doing the
Wow.
neck movements, I was like, oh my gosh, what's that? What's that? What's that? That smells good. That's here. Oh, what? Oh, yeah, sorry.
Well, I mean, that's the way it is. For a while, you're what was it, prairie dogging, where you're up, you look around trying to figure out what everything is.
Yeah, exactly.
You see it a lot in offices when there's a noise and people stick their head above the cubicle and it's like, what was that? What was that? Yeah. So
Yeah.
it's a form of prairie dogging
Yeah.
going on. But so yeah, that was an interesting find right there in my house. But so I gotta say, it was some good memories in that stuff.
Yeah, I bet.
Well, there's other random stuff here too. Other random T-shirts I picked up over the years, but held on to because they were important, like my yearbook T-shirt and other soccer jerseys I had. So yeah, fun stuff.
Class of '78.
Jackass. I'm not that old. Try class of '98 in high school. See, I am old enough compared to you, especially without you making it worse.
Nah, I'm just kidding. You're not old. I just give you a hard time, and I'm starting to feel that myself here as I near the scary age of 30.
Oh, shut the hell up.
Shut
up.
And it's scary, as you know.
Actually, 30 wasn't that bad.
It's 31 that gets you.
No. 31 isn't going to get me. I know the year that's going to get me, and it's still coming up for me. It's going to be my 36th birthday. It's going to be my... And the reason is this. Every time you fill out a survey right now for, like, anything, like online, they ask you, if they don't ask you your exact date, they ask you what your age range is, right?
Right.
And it's always like, are you under 18? Are you 18 to 21? Are you 21 to 35? They always ask you that range because 18 to 35 or 21 to 35, depending upon who's doing the segmentation, is like the most lucrative for advertisers. 36 is going to be the first time in my life I have to answer, no, I'm 36 to 54. I'm middle-aged. According to advertisers, I'm middle-aged at that point.
Just ignore me. My money has gone. Poof.
Exactly. I have no disposable income. I have 30 kids, and yeah, just ignore me and don't try to sell me anything. It's over. My life as a consumer is done.
Sadness.
That 36 is going to be the year that gets me because until then, I'm still technically young, hip, and trendy according to advertisers. But cross that threshold, you become middle-aged, you become an old man, and that is that's
your money's no good here.
Money's no good here, and then God help you when you cross. It's like 55 on to death is like how the marketers look at it. It's like 55 to grave.
Yeah.
That's one of the things that that's the age I'm not looking forward to is 36. It's weird. The big O's don't bother me. I had more fun with them than anything. 30 was completely cool, actually. I had a little bit of belly aching at 29 because I was loathing 30, but when 30 actually hit, it just wasn't that big of a deal. A little depressed, a little bit of introspection, but nothing serious. 36, that's going to be the one that kills me. I see it coming now, and I'm about to turn 34 next month, middle of next month, and yeah, so that's the 2-year warning on young, hip, and trendy, according to advertisers. So, 2-year warning coming up.
This leading cause of suicide is not wanting to leave the key demographic.
Yes, I don't want to leave the target demographic of young.
Wow.
I've always found that breakdown very interesting, and I don't know if they just pulled 36 out of their butt, because it's 35, 36. As long as you're 35, you're still in the group, but
right.
It's 18 to 35, 36 to whatever. I don't know if they pull that age out of their butt. I don't know if there's some kind of science, but that is, how it works. I don't know.
Good question. I don't know either.
So... and then it's sad for me because, technically I studied advertising. I really should know this, but I totally don't. I can tell you basically everything you need to know about yourself based upon your zip code, but I can tell you next to nothing about that. Yeah, zip code marketing is very interesting. If ever you get a chance to look that one up, it's actually a very interesting area because zip code as a breakdown for demographics is fascinating. You can tell the racial demography, the socioeconomic demography, likely the gender demography. You can pretty much guess everything you need to know about a person based solely upon the zip code they live in. You can make at least a very good guess.
Interesting. Yeah, I mean, it kind of reminds me of how credit card companies I've read before can like guess what's happening in your life based upon the money you're spending and how you're spending it.
Oh yeah, totally. And where you're spending it.
Yeah.
Which is funny because even when I tell the credit card companies where I'm going to be spending my money, they don't seem to understand. I have twice had credit cards temporarily suspended while I was overseas, despite calling and telling them I'm going to be in England or Netherlands or Hungary or somewhere. And I need money, you know? I don't want to starve while I'm in Hungary. I don't want to go hungry in Hungary.
Yeah. Hungry Hippos.
Oh God, hungry hippos. All right, this episode just got titled. Well, on that note, all right, you want to talk about some copyright news before we make any more bad puns? Well, I'm sure we'll make bad puns while talking about copyright news.
Let's do it.
Because our first story actually has a bad pun in the title, and it's Sherlock Holmes and the Vanishing Copyright is the title of the Washington Post article we're linking to here.
That sounds like the worst Sherlock Holmes story ever.
It does. It sounds like very mundane. It's Sherlock Holmes and the Dancing Men. Final problem.
It's he finally tracked down the case in the U.S. He found that it was 95 years past, and copyright had vanished.
Yeah, but man, long and short of it is that the estate of Sir Arthur Conan Doyle has appealed to the Supreme Court for an emergency stay in its case involving Leslie S. Klinger. Now, I think we talked about the circuit court decision of this one, didn't we? I'm trying to remember. It all happened very quickly, huh?
We talked about this stuff numerous times.
Yeah, I can't remember if we talked about it, but basically, Klinger is the editor of a book called the New Annotated Sherlock Holmes. Basically, it's a bunch of Sherlock Holmes fan fiction, if we're going to put it in the most blunt of terms. Unofficial Sherlock Holmes stories, if you will. Most people who have assembled these types of books have typically paid the estate at least some kind of license. She refused to play along. The estate sued for copyright infringement. But the estate noted that, hey, wait a minute, nearly every single Sherlock Holmes story, all except for about 4, literally, are in the public domain. Clear as rights, no questions asked. That for the character should be in the public domain, and that ends it. Well, the case actually made it to the Seventh Circuit Court of Appeals, which expressed some disdain and some displeasure at having to discuss such a mundane issue, but the court concluded that the entire character, other than any facts that were unique to those 4 stories in copyright, were indeed in the public domain, therefore the book could move forward. Well, the estate filed an emergency appeal with the Supreme Court for a stay on the book until the full case could be heard. That was now rejected, is the new news. So basically, it is over for this case unless the Supreme Court surprises the world and decides to take it up and actually analyze it. But typically, if they were going to do that, they would have issued some kind of stay. They would have taken some kind of action at this level, and they chose not to. Therefore, most likely, they're not going to hear it. So this case is pretty much over, and in the United States, Sherlock Holmes, the character, not all of his stories, but most of his stories, are now definitively in the public domain.
Wonderful.
Yeah, and this is the thing. I mean, I'm pretty sure Klinger could have resolved this dispute much more cheaply and definitely much more quickly by just paying the licensing fee. But she chose not to, and as a result, we now have a ruling confirming what most people had widely suspected, and that is Sherlock Holmes has expired as far as his copyright goes. He's expired as a character, too. He actually expired and was brought back once. But that's because Sherlock Holmes was probably one of the world's first superheroes, technically, and that's what superheroes do. They die.
Well, we don't know what the fee was, though. What a fee could have been, do we?
No, we don't. We don't really know.
Yeah, but, I mean, so it's a question mark there as far as the fee. But also, I think in this case, you have an attorney.
Mm-hmm.
Klinger is a lawyer in California,
Yeah.
it says here. And so, I mean, you might have someone who wanted to take I don't know, portray favorably a principled stand
Mm-hmm.
on what maybe they saw as an abuse of the system. And they were victorious at the end of the day here, and they're going to save some people some money, or some people some aggravation,
And some
obviously.
navigation too.
You know, those newer stories are still copyrighted, but there's a certain amount of the canon that you can now play with however you want. And so I think I'll be interested to see what that means as far as I don't know. I guess we know what it means. I mean, we'll see a lot of these works probably come out through all sorts of different ways now, online, ebook stores. I don't know if that was already happening. I mean, I don't think it was already happening, right? Because there was some dispute here about how those early works were protected, even if they were 95 years or however many years they would need to be.
Yeah, well, I mean, the estate had been arguing that basically Sherlock Holmes was an evolutionary character, and that the character of Sherlock Holmes was not done until that last story was written. Until the ink was dried on that last, final, in copyright story, Sherlock Holmes, the character, did not exist as we know him today. And I, like most people, found that to be kind of a weird argument. You know, I understand that he is an evolutionary character, but I mean, come on, you know. It's not like half of his stories were in or half of his stories weren't. You know, we're talking about the goal line is way down there somewhere, and they're trying to claim, you know, that just because it's down on the 1 yard line, so to speak, that nothing happened, and that the whole thing is invalid. No, Sherlock Holmes is definitely in the public domain as a character, and in fact, most of those last few stories really don't introduce many new elements to the character at all. I mean, I think there was a mention that he worked for a private detective agency before going private, but honestly, I didn't know or remember that, and I consider myself a pretty big Sherlock Holmes fan. So either I read them and forgot that detail, or, you know, didn't read those stories, or something else. But yeah, even I didn't know that. So there you go.
What's the likelihood or possibility of people who had paid a licensing fee now going back and trying to recover those funds?
Probably pretty low. I suspect in many of these cases they were also paying for the ability to be an official, you know what I mean? Having that stamp of and seal of approval, not just for the copyright issues.
Mm-hmm.
So I think that was a part of it too. So it's unclear what they would be entitled to. And the other issue is it's probably, like I said, it depends upon the license fee, but there's no reason to believe that the Sir Arthur Conan Doyle estate, you know, sold those fees in bad faith or did anything, you know, immoral. So it's going to be they might be able to do it, but it'd be a difficult argument to make, and they probably would spend more money trying to reclaim the fees than they could ever hope to recover. So there's not much to be gained by that fight, honestly. I just don't see that being a popular activity. But someone may. It's not to say no one's going to do it. Someone may. I just don't think it's going to be widespread.
Yeah, it depends on, as we kind of talked about earlier, the amount of the fee. If it's worth the time to get it back, whatever it was, and you know, I'm sure they've been licensing various works, big and small, you know, all the way up to the Robert Downey Jr. motion pictures, down to I don't know, books, you know, individual books being sold. So yeah, is this the last we'll hear of Sherlock Holmes?
I doubt it. As far as on the show, maybe there is still a lingering issue, but it doesn't deal too much with us about the trademark and the name. But that's a trademark issue, not a copyright one. So, you know, we can sidestep it.
We ignore that part of law.
You know, we just totally ignore trademark and don't talk about it. Well, this next story has been lighting up my Twitter feed. I don't know if you've seen this story or the variations of it, but they call her in the headline here on Reuters YouTube star, which that to me is kind of a weird expression here, YouTube star, as being a term. I mean, I get that YouTube star and YouTube celebrity. It's like, you know, you're a celebrity that's on YouTube, not, you know, a YouTube star. It's like, you know, people know her outside of YouTube too, is what I'm saying.
Oh yeah, I gotcha. Okay, I was wondering. Yeah, she's definitely a YouTube star. I mean, by whatever terminology of that.
Well, I mean, no,
you're just saying she's bigger.
I'm just saying that, YouTube is not like an enclosed environment. It's not this place where she's only known. Or people are not only known on YouTube. People that are known on YouTube are known more broadly these days. YouTube's ubiquity pretty much guarantees that. And I ran out of air. So that's my argument. Is that there should be no thing as a YouTube star. It's just online video star or whatever you want to describe her. Makeup video star, whatever. But anyway, YouTube star Michelle Phan, who has earned a name for herself with makeup tutorials, which you probably can tell from watching the video that I have not seen a single one.
I've seen some of them, parts of them. Yeah.
Yeah. Okay.
Yeah.
I watched
a few. She's very popular.
I watched a few after reading this story and hearing about the lawsuit, but not before. Yeah. I was curious as to the background.
I get around, Jonathan. I'm cultured. I get around.
Oh, God. You're one of those episodes, aren't you? You get a little big for your britches lately. As my grandma used to say. But yeah, she is being sued by Ultra Records LLC and Ultra International Music Publishing LLC because apparently in her videos she has background music, which many YouTube stars do. And in at least some of those videos, she used music from very popular DJs such as Cascade. They've also said, I believe, Skrillex is involved in this, and a few others. Well-known electronic dance music DJs. And long and short of it is, they say that she did not obtain a license to use the music, and therefore they are suing her. Now, Phan, for her part, has come back and in another article, it's not in this one, admittedly, has said that, hey, I thought I had permission. In fact, we're preparing a counter lawsuit now, is what she's doing. And some of the DJs, including Cascade, have come out in favor of Phan, saying that they're fine with what she's doing, they have no issue, but they signed over all the rights to Ultra, so they really don't get a say in this lawsuit, which is probably very true.
Yeah. Yeah, the story at TMC, it says Ultra fully agreed to allow Phan to use the music and feels her videos have promoted their music and showcased them to an international audience. You mentioned Cascade on Twitter. He said the following on Adweek. Scroll down. It said summary. I'm not suing Michelle Phan. Ultra Records isn't my lapdog. I can't do much about the lawsuit except voice support for her. I find that Michelle Phan has great taste in music, and knows secrets on how to make my eyes really pop. What's not to like? Yeah, so, I mean, this is, I don't think it's as clear as it might have first looked from the lawsuit. On the dance music side, it's could be one of those cases that we discussed where it's a left hand, right hand, and they don't know each other very well. One hand is promoting music, one hand is suing people. So I think maybe there's a miscommunication here within the label. I mean, it's very possible. It could be. It could be that she used the music illicitly. I don't know how old these videos are, so I'll have to see how far they go back. But especially within the last few years of her being a celebrity, I kind of doubt that she would use music without some sort of at least email, verbal arrangement. So hopefully there's a paper trail here. And I guess we'll see where it goes. I think there's two sides to the story, and they both have to be heard.
Yeah, this is one of those someone done goofed moments, Something obviously broke down somewhere between Phan and the label here, and whether it's, like you said, the label, right hand not knowing what the left hand's doing, or whether Phan thought she had permission but she really didn't, or maybe she didn't get permission from the right parties, or whatever. Something broke down, and the lawsuit will have to hash it out. Now, one of the things that's been getting a lot of attention is people have been asking, what does this mean for other YouTube users? Do I have to worry about being sued? And the answer is probably not.
Yeah.
The reason Phan's being targeted is because she's very, very successful, like 1.6 million subscribers and growing. And to me, I got to
actually it's more like 6 million plus subscribers, isn't it?
Oh, it is 6 million. I thought. Okay, I don't.
Yeah, 6.7 plus. 6.7 million.
Oh, sorry, 6.6 million. Yeah.
Yeah.
So millions and millions of subscribers, millions and millions of views.
Yeah.
Incredibly popular, undoubtedly making very good money off these videos. She deserves her success. That is not begrudging at all. But that's what makes her a target. Is that clearly there is money at stake here and money for Ultra to target. Most YouTube users, probably not the case.
Yeah. Back when I used to run Bad Boy Blog and we used to do certain things with audio, I would get permission from a person in marketing, but in the back of my mind, I would always think that one day something might come of it, where someone else would say, hey, you didn't get permission, and then I have to have those emails at the ready, and see what happens, because that's how it works in a lot of cases. People get permission who are at the company. It's not like it was some guy at Walmart that I spoke to and asked for permission to use this
Hey,
CD
Chuck.
in my. Yeah, exactly. I mean, I didn't go like to him and say, hey, I'm gonna buy this CD. Can I throw it on my interview with the group that sung this song? No, I talked to the head of whatever marketing it was and asked him, can I put this song behind the interview we're doing? And he said, yeah, sure. So you never know. I mean, I did a quick search for Cascade on her YouTube channel, and I found numerous videos where Cascade came up, and one of them I just opened up was from '09, December 30th, and it said, if you like music, please support the artist and purchase these songs, and list various songs with iTunes links. I mean, there's sort of a thing that happens when you get a certain amount of influence and you get an audience is that sometimes these sorts of arrangements are almost either paid for or given because of the interest they generate for the artist and the sales they generate. If you look at and just a recent example, somewhat relevant, is just Weird Al. We talked about how he's giving people the video. He's not getting paid. I saw him doing interviews. He said, I'm not getting paid by Nerdist. I'm not getting paid by XYZ. They're paying for the video to be made, but they're going to monetize the video and make money from it. And he had just had the #1 album in the country for the first time in his entire career. So there's definitely, this is how companies often try to use the influence of online quote-unquote tastemakers, is to get them to use their songs or get them to use their makeup or whatever it is. So I'd definitely be interested to see how it plays out. And I kind of think that with these videos, she might have even helped the sales. In fact, I have no doubt that she helped the sales. Doesn't mean she was right to do it if she did it illicitly, but she certainly helped the sales of the videos, and she was encouraging sales. I've been on YouTube many times where audio is played, and people in the comments are like, "What's that song? What's that song? What's that song?" So it's definitely a way music gets sold in this day and age. And if not in this case, there are certainly other labels that are asking, begging, wanting popular YouTubers to include their song in a clip.
Mm-hmm. No doubt. And one of the other things I just thought of was I wonder if maybe Fawn did get some kind of license for it. The license might have expired.
Yeah, anything's possible.
I'm just thinking anything's possible with how this miscommunication happened. She clearly believes she has permission. The label clearly thinks she does not. Now, the label did say they sent her cease and desist letters that were ignored. But
yeah, the tricky thing about that is that how
did they send it?
No, not just that, but how does she acknowledge it? What, does she pull down every video? You can't just take the song out of. How should she acknowledge it? You can replace audio, but she's not going to re-record her voice talking over a video she released 4 years ago. I don't know. Not to say that the burden isn't on her to respect the artist's copyright, because it is, but it's kind of an odd circumstance because, I'm looking at another one here. This is from '08, and it has a buy song link on it. Like, it's been recognized and accepted by Content ID. That it's this person's song. There's buy links on it, and there's they might even be monetizing it. I don't know, but it's recognized as a song there by Content ID. So I don't know. I guess we'll have to see. But it is hard as a YouTuber who gets popular to say, okay, I'm going to rip this out. But again, the burden is on her if she did something that she shouldn't have. I would ask, what took you 6 years? It's not like it's not like Content ID just came out. It's not like you could have. You had some reasonable opportunity to know about it, I would think, but maybe that's not fair.
Yeah. Well, and the other, it's one of those situations where things that you do that might be technically illegal but are ignored or tolerated when you're a small-time YouTuber.
Right.
Suddenly, there's a point where it means serious legal trouble.
Yeah.
And that seems to be, I have a feeling that may be what happened here, and that may be why it took 6 years, is that she didn't have the audience, she didn't have the presence. But that being said, you have that statute of limitations issue. There is a statute of limitations of 3 years from whenever Ultra Records became aware or should have become aware of the infringement. You're not just allowed to sit on an infringement forever.
Yeah.
So that could be a potential issue raised too. But I think the first and foremost issue is going to be, did she have permission? If so, how and why did this miscommunication happen? So That to me is item one. Everything else is secondary.
Yeah.
Well, turning our ship a little bit toward Aereo again, Aereo has suffered yet another setback. Remember, they're the TV streaming company, lots of tiny little antennas, one per customer, $8 a month, record and playback over-the-air broadcast television. Well, the U.S. Copyright Office came out and has denied them, denied and not denied at the same time, their request to be classified as a cable company. Now, Aereo had the idea after the Supreme Court loss, they would just say, hey, okay, fine, you're going to treat us like a cable company, we will be a cable company and apply for a statutory license for the content under the law. So that's exactly what Aereo did. They applied to the U.S. Copyright Office to be a cable company under Section 111, and the Copyright Office said that they don't feel Aereo Qual meets the qualifications under that section of the law. However, they are keeping it open, so to speak, pending court rulings.
Yeah, this doesn't sound too good for internet companies who want to do something with transmissions of cable television, or I'm sorry, basic
Broadcast,
cable, or it doesn't sound too good because it says that in the view of the Copyright Office, internet retransmissions of broadcast television fall outside the scope of Section 111 license. So it doesn't sound good for pure play internet companies who want to innovate in that space. It sounds like the license and that whole system won't apply to them, and maybe that speaks to, I don't know, litigation or not litigation, but the that section or the laws in place needing to evolve a little bit or change, or obviously laws are usually behind the latest trends in technology, or maybe this, I don't know, maybe it's not supposed to apply to internet companies, but more and more that's how people are consuming their media, whether it be television, movies, music. So it seems like something that should be able to adapt if people want to be legitimate. Yeah, not that Aereo is ready to do it now. Maybe Aereo needs to adjust how they do business. Maybe needs to adjust their technology, their organization, whatever. But it just seems difficult for someone to do that if there's no opportunity for them to do it legally other than paying the highest, whatever license the cable companies want.
Yeah. And it's interesting you raise that because Section 111 is actually one of the newest areas of copyright law. It's one of the newer ones, but it's still from the 1990s. In the early 1990s, I think it was like 92. I don't remember the exact year, but sometime mid-early 1990s. And so, yeah, just imagine how different the internet was back then versus today.
Yeah.
It clearly was not written with the internet in mind. It couldn't have been.
Right.
They couldn't have foreseen that we someday would have YouTube stars. Yeah, I'm not getting over that anytime soon, for the record. YouTube stars and all that. They had no concept of that. And so, yeah, maybe it's an area that's right, that congressional review of copyright that's ongoing. Maybe this is an area right for them to look at and consider adjusting and tweaking and modernizing. That may be the case. Now, one other interesting thing that came out of this filing was, since part of it was that Aereo had to reveal how many subscribers it had to determine how much it would pay. That's part of the statutory license process. Right. We learned that Aereo had just shy of 80,000 subscribers, 77,000 subscribers, I think it was in that ballpark. Change. So a lot of people were really down about that number, saying, oh, Netflix has 50 million, Hulu has 6 million, blah. But I would counter saying, Netflix and Hulu really aren't direct competitors in that regard. They're not really doing what Aereo was doing.
Yeah, they're not. And also, Aereo had to operate with a cloud over it. I mean, even though they won, they couldn't go at the speed they wanted to go at. And if you researched the company, if you Googled the company, you saw litigation. So, well, I don't know. I'm not really. I don't know. Am I down on that number? Am I surprised? Is it low or high? I don't know. It doesn't seem low. It doesn't seem high. It seems like a healthy number that gives some sort of indication that there's a market there.
And to be clear, this number was for 2013, not 2014. That report last year's numbers, for one. Yeah. And the other thing about it is, remember, Aereo had to build out city by city.
Yeah.
I mean, Netflix flips a switch, boom, they're nationwide. Hulu Plus, same deal.
Yeah.
They flip a switch, whole country's covered. You can get like Guam and that type of stuff, But for Aereo, it had to be city by city. It was New York, it was Boston, it was Atlanta, and so on and so forth. Now, New York, by the way, had the most number of subscribers. Big shock, I know, of 27,000. Most other cities had between 10 and 12. So just interesting. I don't know if it really impacts anything, but it's interesting. I found it moderately fascinating and enjoyable information to glean.
Yeah, it's interesting.
So, well, also this week, a brief update on the continuing fight, and the very messy continuing fight over the new Hobbit movies. My story's not loading. Come on, load up. Basically speaking, there's a huge controversy, though, about a deal that was signed way back in 1969. That deal basically is what gave the movie rights, at least the movie rights, that would eventually land in the hands of the company of Warner Brothers that went on to make the film. Now, Warner Brothers alleges that the deal actually gives them permission to do all kinds of things, like make video games and toys and all kinds of other stuff. But and also to make these multiple films. However, the people who gave the rights up, who signed it over, United Artists were the original people who signed the agreement. But anyways, the people who signed over the rights are saying no, it doesn't. However, only 2 people are actually still alive that were at the deal signing. And interestingly, those 2 people were hired as expert witnesses by Warner Brothers legal team. And that was viewed as a ethical no-no, if you will. So the Saul Zentz company, the other litigant in this case, sought to have the lawyers removed from the case for this activity. They will not be removed, but they have sort of given those quote-unquote expert witnesses the boot, and they will be called as just, witnesses in the case. So
Interesting.
It's a pretty interesting and bizarre case, and it involves probably one of the biggest and most important intellectual properties going on right now. So yeah, and to see it get so dirty so quick, it's kind of mind-blowing. Just wanted to very quickly touch on it, though. I didn't have much I really wanted to say about it.
Yeah, I mean, so they were trying to get the estate of J.R.R. Tolkien's attorney taken off the case because he had supposedly had some sort of privileged access to those 2 people you mentioned.
Yes.
So that's the main thing here, is that they're going to now get to keep that attorney.
They get to keep the attorney, but those 2 19 attorneys from the original signing are no longer expert witnesses. They've been demoted to just witnesses.
Yeah, what's the sounds so clerical. What's the really big deal there? Will they not be a red carpet and banners on the while they testify? There won't be like a United States flag draped over it or something. What's the big deal here?
As someone who has done this, I can tell you the exact difference. Expert witnesses get money, and they are certified, and actually they are certified as experts by the court in their field too, and their testimony is given additional weight. But since they were actually there, they're technically
I was gonna say,
I'm sure they are experts on the signing. They're the most experts we can get, but. Typically speaking, expert witnesses are testifying in a field. Like I testify as an expert witness in plagiarism. You might expect.
You cash those checks.
Exactly. Expert witness testimony pays extremely well, by the way. If ever you can, I recommend this.
Why doesn't anyone ever need anything of an online community? Dang it, no one ever needs anybody to testify.
Oh, I am sure if you put it out there, there's a court case that would call you. I am 100%.
I'm going to register our website, Online Community Expert for Testimony.com.
Just give it a shot. You might get to visit an interesting city and get asked to testify in a case.
My point is that even if they don't have the expert name tag affixed to them in the court, it's going to be pretty clear their status conveys them a certain level of expertise, and that they're the only 2 people living who were there.
Exactly.
It's pretty clear. It's like if you wanted to talk about when the Declaration of Independence was signed and you had one guy alive who was actually there, that guy would get a certain level of reverence in the court.
Yeah. And the other thing about an expert witness is that they are for one side or the other.
Mm-hmm.
Where a witness in the broader sense can be subpoenaed and can offer testimony that helps and hurts both people.
But is there a limit to the questions that an expert can be asked? I mean, are they?
They are only asked questions within their field.
Right, but I mean, but the other, okay, I gotcha. But the person they're testifying against, so to speak, can still ask them the same questions they would if they weren't an expert, right?
Yeah, exactly. No, they get asked, and cross-examination.
It's almost like a matter of disclosure.
Yeah, it is.
More than anything else, it's almost like an affiliate disclosure on your blog. It's like, expert witness means I'm working for this guy.
Basically, they're saying these witnesses are not getting paid, and at least officially, they're not on this guy's team.
Gotcha.
It's somewhat clerical, but it does actually carry some weight in the courts. So
there's a startup idea: pairing expert witnesses with the defendants and the plaintiffs that need them. It's a new social network.
I have no doubt it already exists somehow. I'm pretty sure it's like a subnet of LinkedIn or something does this. I'm 100% sure. I haven't found it. I haven't really. I'm not too involved.
It's some deep dark section on like some legal website behind a paywall.
Probably. Probably. Well, Malibu Media, we've talked about them a fair amount. They are commonly referred to as a copyright troll, and that they're known for filing these huge lawsuits seeking information on dozens, or even hundreds of alleged file shares of their content, which happens to be pornography in their case. Well, they scored a pretty significant win against a defendant, Don Buie, who is alleged to have downloaded 57 unauthorized copies of Malibu Media movies from the site Kick-Ass Torrents. And he claimed in his defense that he had no idea what he was doing. He thought he was simply ordering them.
I don't even know how to use a torrent program. And I'm fairly technically savvy, okay? I gotta say, I don't know how to use one because I've never downloaded one. Like, and that's not to say there's something wrong with BitTorrent or torrenting. Obviously, there's plenty of things people do that are not illegal. The first thing people always trot out is Linux distributions, and I've never needed to download Linux, so I've never used a torrent program.
Well, it's funny. This is true. I had to download Linux last night. I was doing recovery on a hard drive. And one of the things you can do is download a Linux distro, burn it to a CD, and just boot off the CD. And that gives you access to everything and lets you try that way, right? Mm-hmm. And I realized I did not use BitTorrent to download Linux. I used a direct download of Ubuntu. So yeah, that happened.
There you go. So you don't even need to do that.
Even that excuse is waning. It used to be a bigger deal back when direct downloads sucked.
Right.
But yeah, in 2014, apparently it's less of one.
Anyway, sorry to interrupt you there. So he didn't know what he was doing. He thought he was ordering movies by using BitTorrent through Kick-Ass Torrents.
And the long and short of it is, he claimed, and he likened it to being a guy going to a CD shop and then accidentally purchasing a pirated CD or having one slipped into his bag. He also pleaded that his English is not the best. He is a naturalized U.S. citizen, but he is a Vietnamese, as the name might have indicated, and he does not have a strong mastery of the English language, so that confused him as well. But the judge didn't buy any of the arguments and basically said, look, you did infringe. Copyright is a strict liability issue anyway, so even if you didn't intend to infringe, it only deals with, the amount of damages, not whether or not you are an infringer.
Yeah, and what kind of CD, not to say it doesn't happen. What kind of CD shops are you going to that's you pirate CD? Because I know it happens, and it happened more in the 90s, okay? I'm sure it did, especially on small ones, not like chains, but, small corner shops. I'm sure that it happened.
It did.
But, I did buy CDs in the 90s. I would usually go to chain-type stores. It wasn't FYE or that sort of store, but it was like that. There was one, I'm trying to remember what the heck it was called, I forget. But I bought CDs, and I never really got a pirated one. I own some CDs that are pirated CDs, but I bought them for the curiosity of it. And in almost all the cases, I actually own multiple copies of the songs on those CDs. I just wanted the oddity of what the heck this person did to make this stupid CD. But yeah, what CD shop are you going to today that actually, first of all, you're not going to CD shop, okay? That's first of all. Okay, you might be going to Walmart or Best Buy or someone that sells CDs and it's a small part of their business, but dang, that's not a good excuse. And I like how his lawyer describes him as a poor sap. Which,
This poor, stupid individual. I mean, look, he's
smart enough to
apparently
figure out how to
dribbling on
BitTorrent.
himself.
Yeah, smart enough to figure out how to BitTorrent, which he said a friend installed for him, which I guess I could buy. I mean, I can buy that people who are less technically savvy have a friend who is more technically savvy and say, "Oh, you don't know about the internet, that place where you can download all the movies you want for free? Let me hook you up." I mean, I can actually buy that, but what I find tough to buy is the combination that first of all, he's smart enough to use the program, but he's not smart enough to know that piracy happens on the internet, and he's not smart enough to know that you generally pay money for things. So it's kind of a weird kind of conglomeration of different facts that I don't think stands up very well, and obviously here we have a loss in the court, which, I mean, this company is going to eat up because they were able to find some quote-unquote poor sap, which actually is pretty accurate. They were able to find a poor sap that'll put a case on the books where they won.
Yeah, and he is a poor sap. He is a poor sap for a lawyer who made arguments that had nothing to do with copyright. Copyright is strict liability. So even if all these things were true, even if we did concede he was the biggest idiot in the idiots of Idiotsville, none of it would matter. You know, it's irrelevant to whether or not he infringed.
He doesn't even have a good, like, I let someone use my computer defense.
No,
like,
I mean, he didn't.
Come on! I mean, come on! Look at what other people do.
He didn't trot out the open Wi-Fi, the other people have access to my computer, or the popular one with Malibu Media has been that Malibu Media was alleged, remember this was a while back, they were alleged to have seeded some of the torrents they were suing over.
Yeah.
So the honeypot aspect, they didn't trot that out. They didn't target any of that. No, just look, my client's an idiot. Was the basic crux of the argument, and it fell flat. Now, we don't know what damages he owes. Damages have not been determined. That may be the subject for a trial. But it's going to be somewhere between $42,000 and $1.7 million because there's 57 files involved, and it goes from the minimum to the maximum as a non-willful infringer. And I got to say this: you hit me with any judgment in that range, you're going to get about the same amount out of me.
Right.
Doesn't really matter, you know. 42,000 is just as bankrupting as 1.7 million.
Yeah, I mean, I never filed for bankruptcy. I've never paid any attention to it, so I don't know. But is there some sort of harsher penalty for having more debt as opposed to less debt?
No,
like, if you have $5 million in debt, are you in more trouble, credit-wise, and whatever?
No,
what
not
is it?
really.
If you have 10,000.
Not really, no. It doesn't really matter. But the real question I have, and this is something I don't know, maybe one of the lawyers in the audience wants to help me out. In fact, I know who I could call to find out. My good friend is a bankruptcy lawyer, but I don't know if this type of debt is even dischargeable in bankruptcy. You may not be able to get rid of this, which means you have to pay whatever you can on it until you pay that amount. Now, I don't...
So what kind of debt are you sound on? A court judgment type of debt?
Yeah, a court judgment. In this case, it'd be a court judgment. And I know there are some court, last I recall, there were some court judgments which can be, some which can't. It depends upon certain quirks in the law, and I just don't remember. My bankruptcy law is not my thing.
I'm not looking this up on Google. Continue.
Okay. But yeah. But, I mean, it was a terrible setup of defenses, and it was interesting. I actually read the article on Tech Dirt. Mike Masnick, we all know his leanings on these types of things. He's very much against people like Malibu Media. But even Mike Masnick was basically calling this guy and his attorney an idiot and telling them that they were making terrible arguments that were obviously deeply flawed. So, yeah, when Mike Masnick is telling someone against the copyright quote-unquote troll that he's an idiot, it's pretty serious. Any luck on your end?
I was looking, there's an article on Nolo.com.
Okay, Nolo's a good site.
It's about, will bankruptcy get rid of lawsuit judgments? And it doesn't have an author, I don't think. Oh, Stephanie Lane. Stephanie Lane is the author. Okay. And it just says, let's see, you may be able to discharge your personal liability on that judgment in the Chapter 7 bankruptcy. It depends upon whether the debt is dischargeable or non-dischargeable. So,
wasn't that what I just said?
No, but okay, so there is some qualifications for that, though. Now, if If the starting point is figure out if you are still liable on the judgment is to ask whether the underlying debt is non-dischargeable. Well, I would hope so. Yes, ask if the debt's non-dischargeable. But certain debts are automatically non-dischargeable, including the following: student loans, child support or spousal support, debts owed to government entities like fines, taxes, court costs, restitution in criminal cases, etc. Post-petition HOA and condo fees. That's a weird one. And death or injury caused by DUI. If the basis of the judgment does not fall into any of the automatic non-dischargeable categories listed above, you may not be off the hook just yet. There are other types of debts that can be accepted if the creditor files an objection. Sorry. Is there any hope in sight here for this article? Let's see. If the judgment creditor files an objection to your discharge and proves the debt to be of any of the following types, it may not be dischargeable. Okay, so if it's an injury caused by a willful or malicious act, such as assault,
Okay.
if it's fraud used to obtain money, goods, or services, such as lying on a credit application, or if it's fraud committed while in a position of trust, such as embezzlement while acting as a trustee or guardian, if it doesn't relate to those and the creditor doesn't object, then you can discharge it.
Okay, so that means there might be a difference, and this is a theory here, it might be a difference between willful and non-willful infringement in terms of discharging a copyright judgment in bankruptcy court. This is a theory. I'm going to have to look this one up and spend some time on this.
Yeah.
But if that's the case, then it makes a lot of sense for this lawyer to try and set up his client to be a non-willful infringer, knowing that once this whole thing is resolved and the judgment's made, he's just going to file for bankruptcy and discharge the whole thing.
Yeah, I mean, you'll have to forgive the articles not focusing on copyright infringement.
Well, yeah, that's kind of a weird thing. Okay, I admit it.
Yeah, and actually what the heck is this? I'll look at this while we go on. There's something interesting here I just read, and it's from pepperlaw.com. It's actually an attorney at law. It says, court clarifies discharge of judgments for willful intellectual property infringement through bankruptcy. In other words, it sounds exactly like what we're talking about here, but it's a bit long. It's a bit long.
All right. Okay, well, we'll ignore it for right now. But just drop me the link in chat. I want to come back to it after the show's done for me personally. But yeah, so basically, though, this guy made some stupid arguments, lost a case that he might have had a chance at. I don't know. Probably not with the evidence against him. He probably should have just settled it, honestly.
Mm-hmm.
I mean, in a lot of these cases, if you did it, you're probably better off settling it. You know,
especially if you're a poor sap.
Yeah, don't play the poor sap routine is what we learned. Well, switching gears to the United Kingdom real fast, a new campaign is set to begin in the United Kingdom, a quote-unquote four strikes campaign. ISPs and copyright holders are working together cooperatively. And this is sort of a weird, it's based loosely on the Digital Economy Act, but it's its own weird thing here, where ISPs will send warning letters to repeated to suspected file sharers, let them know their activities are illegal, let them know about legal alternatives, yada, yada, yada.
Mm-hmm.
And after 4 letters, then absolutely nothing happens. It's over for the year. You don't get any more warning letters. I mean, come back and do it all again next year.
I mean, good.
I'm really torn on how effective this will be personally. Because on one hand, it's like I understand that people might not, change behavior if there's no threat of punishment. Like even the 6 strikes regime in the U.S. has some, some punitive measurements to it. It's not significant, I admit, but there is an element there of punishment. But the other side of it is that this will shut down a lot of instances of piracy nonetheless. People get the letters, oh, I should secure my Wi-Fi, or oh, I should see what little Jimmy is doing on his computer. And take action that way.
Yeah.
So those cases can probably be resolved. The 16-year-old son in the attic pirating movies all day long, dad gets a letter that, BitTorrent's being widely used in the house, might take some action. So there's still ways this can resolve cases and change habits. But yeah, some have described it as quote-unquote toothless, and I kind of understand why they're describing it as such.
Yeah, it is toothless, but this might be the medium that I think we get in a lot of first world countries.
First world problems.
Because there is a understandable aversion with at least a vocal portion of the population to cutting off internet or throttling internet. Mm-hmm. As people look at internet more and more as something that you fundamentally need in life. I don't know that I like it being toothless, but I think it. I mean, I think it will help some. I don't know what that percentage will be, but I do think it'll help, as you highlighted, as the article highlights, with people who care and just need a little nudge.
Yeah.
They might care if they found out about something. They might not be aware of it. They might not want to be affiliated with that behavior, and so they'll make an adjustment. Again, might not be 20% of the people who get notified, or 30%, or 40%, but I guarantee you there is a percentage of people who will receive that notice and then change something. They might close their Wi-Fi. They might talk to their kids. They might stop doing it themselves because they know someone is aware of it. So yeah. I do think it'll be helpful, and you never know. It could be the first step to something bigger, especially if data supports. If they can find a way for data to support the notices and how they graduate the notices and what happens to people who get noticed or receive a notice.
And they did say that this is kind of the first phase of it. They're going to look at the results, see what happens, and see what further action they need to take afterwards.
Right.
So this isn't necessarily the end, but they wanted to do I think they said it's a 3-year educational trial where they're focusing exclusively on education, nothing punitive, and then they're going to come back later and see if there's more that they can or should do.
Yeah.
And I think that's reasonable. I think starting with an education-first approach definitely makes it more palatable and makes whatever punitive measures, if any, come later more acceptable and understandable,
Yeah.
Well, finally, Candyland. I can't believe we're talking about freaking Candyland in a Copyright 2.0 show. And worse, I can't believe we're talking about the Candyland movie. I mean, movie on Candyland? Has anyone actually played this game? Turn over cards and move spaces.
Yeah, you know what? I'm interested in it, and I'm interested in it. I don't know. I don't know. I mean, was this a game you played as a kid?
Yeah, it was.
Okay, it was a game I played as a kid, and my mom has these stories of how she let me win and how when I didn't win I wasn't very happy, and we're talking about a very small kid.
But it's a pure luck game.
Yeah, well, no, but she would take the card over and over again, or take a different card or something. It wasn't a straight up game. It was sabotage for me to win, which is how I wish life was. But there is a story to the game. There is a backstory. There are characters. I don't know. Battleship felt stranger to me for some reason. Just because Battleship to me was just gray ships. I didn't know any people. There wasn't an Admiral Johnson or something. I mean, it was just gray ships that we put little red pieces of plastic into. I'm interested in this because I love Adam Sandler, and I'm interested to see what he does with it. But it's IP. I mean, it's intellectual property.
Yeah, it is.
So of course, we have some lawsuit.
And that's where the issue stems from, is exactly what you're talking about. Because Candyland, the game, according to this article, was actually developed sometime in the 1940s. They say mid-1940s in this. However, in 1984, which is when I was 4 years old, so right around the time I probably started playing the game.
Yeah.
Right around the time I probably started playing it. A company named Landmark Entertainment Group, sort of did a reboot of Candyland, I guess you would call it. And what they specifically did was they introduced the aforementioned characters. They gave the boy and the girl. They gave, all the weird, like it's King Candy, Lord Licorice, Princess Lolly, and the Lollipop Woods. God, I can't believe these words are coming out of my mouth.
It's awesome. And what about that Gloopy? What's that guy's name? The brown guy is like pudding.
Gloopy, or I know what you're talking about.
Yeah, I don't know if it's Gloopy or not. That sounds right to me.
It's something similar though.
Yeah, I'm going there now. Let's see. What do we have here? Gloopy. Yeah, it's.
Well, your memory of...
you know what? I think maybe I said it Gloopy, but it might be Gloppy. Gloppy. That indicates Gloppy. Gloppy the molasses monster.
You were one letter off in 30 years.
He was renamed the Chocolate Monster in 2010 because kids these days can't know about molasses because it's too obscure. Great.
Really?
No, that's not what they say here. I'm just guessing. Because chocolate is a lot more approachable to a kid than molasses. Like, what's molasses?
I gotta be honest. I'm 34, and I only kind of have a vague idea.
Yeah,
it's sugar.
The main thing you don't want to do is get yourself stuck in it.
Yeah. Actually, molasses is true. I can't remember what city it was in, but a tidal wave of molasses killed over a dozen people in one city after a storage tank broke.
Maybe that was why they were him, because of the tragedy.
I think that was in like the 1910s.
They couldn't have a guy named the Molasses Monster after a tragedy. Oh man,
No.
molasses! You got me searching for molasses killing.
Yeah, the Boston molasses disaster. It's got a Wikipedia
Oh man,
page.
only
And it was in
Boston.
1919. I was right. It was in the 1910s. And it was in Boston, Massachusetts, in the North End. Killed 21 people, injured 150. Killed by molasses.
What a way to go! Oh
Yeah,
man, they're like Gloppy, no!
The original Gloppy
That's
destroyed.
what inspired Gloppy. No, that's not. That's not.
Let's hope not.
I'm sorry to any offense, people.
No. But no, I mean, but yes, apparently when...
Anyway,
okay,
they saved Candyland as a short version, because without those characters, I don't know if I would have played Candyland as a kid. I don't know.
I don't know
I mean,
either.
most likely, I don't know if we would have been seeing a movie of Candyland without those characters. So go ahead.
But anyways, the long and short of it is Hasbro purchased the right to use that intellectual property in the games.
Yeah.
Hasbro then turned around and licensed it for a movie. They licensed it to, who was it that got Columbia Pictures licensed it. So they licensed it to Columbia Pictures for a movie. Now what Landmark is saying is that that original agreement back in 1984 does not give Hasbro the right to license movies based upon these characters, but only to use it in physical games and toys and related items. Movies and DVDs and all that jazz not allowed underneath this license agreement, and that's what this lawsuit is about.
Interesting. Yeah, I mean, there's definitely some money at stake here. I mean, they look like they're going to do a lot with this franchise, with a movie anyway. I mean, that's going to be a big deal. It's going to be a big movie. It's got Columbia Pictures. It's directed by the person who did Enchanted, and it's got Adam Sandler in it. So there's some people that made a few bucks in the movie industry over the years. Yeah, I mean, I'm curious. I do find it interesting that Hasbro doesn't own the characters, if that's how it comes out here. We have we have a case that needs
They don't
to
own them
proceed here.
outright. They have that license to.
I'm surprised they haven't bought it. I mean, there's not it's funny. There's a license for Candyland because they sell the board game, and that's what Candyland is. It's not like there was a Candyland book that they're licensing these characters from. That's the game. So all these years they've been paying a license and providing royalties. I don't know if that's common or not. I mean, that might be common, and maybe I just don't know enough. But it seems different that this is their whole product. It's not like there was a Candyland princess or a King Candy and something else. I mean, they pay these people to make the characters, and now they pay them royalties. It's a good way to do it. It worked out well for that company, I'm sure. But you know, these days I think more and more people own the product they create, the initial product. They buy it from whoever made it. But that's just maybe I'm wrong.
I don't think you're wrong at all. I think you're absolutely right. Or I think at the very least, once they realize that this is going to be an ongoing relationship, 30 plus years, maybe we should just, borrow the money and buy it.
Yeah.
Or just buy it outright. I mean, at some point you have to wake up and go, we're paying these royalties every year. When is it cheaper just to make one big lump sum payment and walk away? At some point that becomes logical. And that's not happened here, obviously. So, long story short, Hasbro does not at least outright own the characters. They have a license. It's all legal in the board game. But is it legal to be licensed in the movie? That's what this lawsuit is going to determine. So it's actually, despite the silliness of the characters and the subject, a very interesting copyright lawsuit.
Yeah.
Well, Patrick, I am all out of stuff. You got anything else? Any final thoughts?
No, I don't think so. I think that story I found will be a good read for you there about the willful
I've got
infringement.
it and where's my chat?
And my scanning of it seems to, fit along the lines with your guess, but I guess you'll have to read it to see.
Yeah, I'll read it thoroughly and find out, and then maybe I'll do a PT post about it sometime soon. I mean,
yeah, that's a good idea.
Says I can't talk about it, but no, it's fascinating. Well, on that note, everyone, my name is Jonathan Bailey. I am from the website Plagiarism Today, which can be found at plagiarismtoday.com. You can find me on Twitter, Facebook, Google+, LinkedIn, Instagram, anywhere else you want to think of, as username Plagiarism Today.
And I'm Patrick O'Keefe. I blog at managingcommunities.com. You can find me on Facebook, Twitter, Google+, and LinkedIn as Patrick O'Keefe.
On that note, everyone, thank you very much for joining us, and we will see you guys next week.